Madam Speaker, on April 29, 2024, I asked the Immigration Minister to explain to Canadians why an individual convicted 5 times of criminal charges facing a deportation order upheld by a federal court managed to get ministerial intervention to stop his removal. Madam Speaker, ministerial interventions are for serious, extreme circumstances, often life and death situations. So I asked the minister if it was his intention to make a mockery of our legal and immigration systems, or was his intervention guided by a political calculation to get more votes for his party. Regrettably, Madam Speaker, the minister responded by stating that these are not matters that we talk about publicly, much less on the floor of the House of Commons. Well, Madam Speaker, given the total mess of the immigration system under this government's watch, I don't blame the minister for not wanting to talk about it. For the record, the minister was not asked to divulge protected, private information. I was asking him why he, personally, intervened in such a clear case of deportation as was upheld by his own department and the courts. Madam Speaker, it's worth giving background on the case, as there are important questions that any reasonable Canadians would ask as to why this particular deportation was not carried out. First and foremost, why did a 5-time convicted person receive preferential treatment? What warranted special consideration for the minister to personally overrule not only his own department, but also the federal courts? I have constituents waiting almost 3 years for family sponsorship, others with loved ones waiting over a year for a visitor visa, but a person with 5 convictions who has blocked the building of national pipeline infrastructure, someone who is sentenced to 2 weeks of imprisonment for criminal contempt of court, and has also served time for blocking the main road to Vancouver's International Airport. That's what warrants the minister's special attention and his personal intervention? Is there something Canadians don't know that makes this person so special to the minister that he's willing to throw out rule of law and the integrity of our immigration system? At a time when Canada is still struggling to deal with the full scope of foreign interference in our country, the minister personally intervenes to stop the deportation of a 5-time convicted person who boasted, Madam Speaker, about $170,000 US in foreign money to fund illegal blockades of roads, bridges, and highways in BC's lower mainland. At a time when the immigration system is leaking like a sieve, where literal terrorists are being granted citizenship after taking part in ISIS terror videos, dismembering the bodies of people they murdered. This is what the minister thinks deserves his intervention. What's the criteria? Because thousands upon thousands of applicants would love to know. Or is there a new liberal 2-tier immigration policy? Does this new liberal policy have a limit on how many criminal convictions is too many? Clearly 5 criminal convictions is no problem for this minister. And Madam Speaker, it's no wonder that this government has been such a doormat to foreign interference when people who boast about being foreign funded as they block key road, bridge, and other infrastructure are saved from deportation. Therefore, Madam Speaker, I'm going to ask my question again. Now that the parliamentary secretary understands what I'm asking, was the minister's intervention intended to make a mockery of our legal and immigration systems, or was this intervention politically motivated to get a few more votes? Thank you, Madam Speaker.
The Honourable Parliamentary Secretary to the Minister of Immigrations, Refugees and Citizenship.
Madam Speaker, I want to thank the member for raising this important issue. In general, applications are assessed on a case-by-case basis. Decisions are made by highly trained officers who carefully and systematically assess each application against the criteria set out in the Immigration and Refugee Protection Act, or IRPA, and its regulation. The IRPA sets out the core principle and concept that governs Canada's Immigration and Refugee Protections Program, including provision relating to refugee and sponsorship and removal, detention, reviews and admissibility, hearings, and the jurisdiction and powers of tribunal. A decision to remove someone from Canada is not taken lightly. Madam Speaker, I would like to add that IRPA authorizes designated officers to issue temporary residence permit or TRPs to inadmissible foreign national when it is justified in certain circumstances. A TRP allows the holder either to enter Canada or to remain in Canada during the validity period of the TRP. A TRP provides the foreign national with temporary residence status in Canada. If the TRP is valid for at least 6 months, the foreign national may apply for a work or a study permit. Upon cancellation or expiration of the TRP, the foreign national must leave Canada. TRPs allow officers to balance the objective of the ERPA to meet Canada's social, humanitarian, and economic commitments while maintaining the health and security of Canadians. Clear records of decisions allows for the monitoring research necessary for the preparation of the annual report to Parliament. The number of TRPs issued is included in the annual report, and they are categorized according to the grounds of inadmissibility. Madam Speaker, I would like to point out that under the Immigration and Refugee Protection Act, a foreign national who, in the opinion of an officer, is inadmissible or does not meet the requirement of this act becomes a temporary resident. If an officer is of the opinion that it is justified in the circumstances and issue a temporary resident permit, which may be cancelled at any time. The Minister of Immigration, Refugee and Citizenship Canada is authorized by legislation to exempt foreign nationals, including those whom may be under a deportation order, from any applicable criteria or obligation of the Act where he deems it's justified on humanitarian and compassionate considerations. The Minister takes this authority very seriously, and as well as his responsibility as Minister to ensure that he is executing his duties in a fair and objective manner. Due to privacy reasons, I will not speak on any individual cases. However, I assure you that he assesses each case brought to his attention to ensure that he exercises his authorities in the best interest of Canada, Canadians, and the people who use our immigration system. Speaker, I hope this is helpful, and thank you, Madam.
The honourable member for Spadina-Fort York.
Madam Speaker, the Parliamentary Secretary said 3 key words: highly trained officers. So why were the highly trained officers overruled by the Minister? I'm not asking for specific case details. What I'm asking for is the criteria with which led the Minister to intervene in the case of an individual that was convicted 5 times by Canada's courts. Because not only did the Minister override the highly trained officers in his own department, he also override Canada's courts. And frankly, Madam Speaker, it must take a lot of deep thought to overrule one's own department and ignore the findings of the court. So I asked the Parliamentary Secretary why, because frankly, I really need something to tell my constituents who are not getting special treatment from the Minister of Immigration.
The Honourable Parliamentary Secretary.
Thank you, Madam Speaker. I'd like to thank the member for raising this important issue. Generally speaking, all of the cases processed by IRCC are assessed individually. Decisions are made by highly trained officers who carefully and systematically assess each application against the criteria set out in the Immigration and Refugee Protection Act, or ERPA, and its regulations. The Minister of Immigration, Refugee and Citizenship Canada is authorized by legislation to exempt foreign nationals, including those who may be under a deportation order, from any applicable criteria or obligation of the Act where he deems it's justified on humanitarian and on compassionate consideration. The Minister takes this authority very seriously, as well as his responsibility as Minister to ensure that he is executing his duties in a fair and objective manner. Due to privacy reason, I will...
I'm sorry, the honourable member's time is up.